Thank you, President. Mr. President, Madam Vice President, members of the Court, it falls to me to respond to the arguments presented yesterday by Mr. Staker around the theme of your prima facie jurisdiction. Mr. Staker argued that Gambia had acted, and I quote, as a proxy for an international organization, and that Gambia called upon the court not as a state party to the convention, but in its capacity as president of the ad hoc ministerial committee of the OIC, that is to say, as a body of this international organization. Mr. Staker inferred that your ratione personae jurisdiction was lacking, and therefore thinking otherwise would be tantamount to circumventing the requirements of Article 34 of the statute. This proposal disregarded reality. It is indeed Gambia that suggested that the OIC adopt the Resolution 59/45 of May 2018. It is not the OIC that mandated Gambia. It is Gambia that sought within the OIC the support of its member states, and that is assuredly its right. Similarly, nothing prevents Gambia to receive financial support from other states. Furthermore, Mr. Staker was in a situation of legal contradiction because he said both that Gambia would have acted as a body of the OIC and as a proxy. Of course, in law, it could be a situation of either or, but in reality, it was in fact neither nor. The fact that the presidency of the ad hoc ministerial committee came back to Gambia due to its initiative does not transform Gambia into a body or agent of the OIC, and in fact it is not in this capacity that Gambia called upon the court. In fact, Gambia submitted its application instituting proceedings, and this legal act is undeniably attributed to Gambia as a member state of the United Nations, and therefore bound by the statute of the court and having access to it. The agent of the Gambia who signed the application is the Minister of Justice. He is the body of the country and was not at the disposal of the OIC and acted or did not act under the official control of this organization or as a proxy. No document having been submitted supports that the OIC gave mandates to one of its members in the present case. The member states of the OIC, in fact, only encouraged Gambia to act before the court. There is no, therefore, proof of the Article 34 being circumvented, it's just that the 56 other states encouraged Gambia, and there is no proof of circumventing the article, even if they all belong to the same organization. And in this respect, it is irrelevant that 13 of the 57 member states of the OIC were not bound by the convention and its Article 9. The proceedings pertaining to the application of 11th November are between Gambia and Myanmar. And the dispute, therefore, is indeed a dispute between Gambia and Myanmar and not between OIC and Myanmar. Mr. Staker recycled his ratione personae argument when the examination of the ratione material jurisdiction of the court was examined. But for the same reasons, it must be rejected. Mr. Staker claimed that no dispute existed between the parties before the 11th of November 2019. That is the day the application was submitted. But my colleague, Mr. Suleiman, clearly explained that a dispute did exist before the session of the court. Mr. Staker first argues that the OIC resolutions are irrelevant to establish the prior existence of a dispute because Myanmar is not a member, and that these resolutions do not contain any positive affirmation according to which Myanmar would have violated the convention, whereas based on the Marshall Islands case, he questioned the significance of Gambia's positive vote. The fact that Myanmar is not a member of the OIC is irrelevant because these resolutions were brought to its knowledge and Myanmar did not refute that because it reacted to them. Furthermore, these resolutions explicitly target Myanmar and the situation of the Rohingyas, whilst they refer to the need to prevent genocide. Such is notably the case of the May 2018 resolution that created the Ad Hoc Ministerial Committee. Resolution 4/46 of March 2019, which was not annexed to the file that Myanmar submitted to you yesterday, but was covered in the application and was annexed to the observations of Gambia, calls on Myanmar to honor its obligations, and I quote, under international law and human rights covenants, and to take all necessary measures to immediately halt all vestiges and manifestations of genocide against Rohingya Muslims, unquote. I doubt that one can be any clearer in diplomatic language. Why ask for the fulfillment of obligations if they hadn't been violated at all to begin with? As to the vote of Gambia to support the resolutions, may I recall that they did not contain a host of different proposals, but they were based on a single theme, and hence the meaning of these voting patterns is crystal clear. Mr. Seko also said that the fact-finding missions reports could serve as a basis to identify prior dispute between Gambia and Myanmar. Gambia is not an author of these reports, but it is indisputable that welcoming the fact that Gambia wanted to refer the current dispute to your jurisdiction means that the UN report had necessarily notified Myanmar, particularly since the respondent rejected the report. So Myanmar couldn't possibly have not been aware of the dispute. Mr. Staker considered that the declaration of Gambia at the UN General Assembly was irrelevant because the Gambian Vice President failed to specifically mention the Genocide Convention. The Gambian declaration dates back to the 26th of September, that is to say, 10 days after the fact-finding mission's report, referring explicitly to the Genocide Convention and welcoming the intention of Gambia to bring the dispute before the court, and 3 days before it was categorically rejected by Myanmar. Does Mr. Staker seriously argue that Myanmar could have legitimately thought that the object of the dispute that Gambia was bringing before the court could have changed completely in a matter of just a few days? As to the Gambian note verbal of the 11th of October 2019, Mr. Staker made several objections but did not deny the fact that Myanmar had received it. According to Mr. Staker, the note verbal did not require any answer because it did not specify any particular fact supporting the charges that it contained.
Mr. Staker is clearly mistaking the requirements of Article 38 of the rules pertaining to content of an application, with the simple need to point out before the application that the parties are in disagreement in regard to certain international obligations. Furthermore, inasmuch as, contrary to other compromissory clauses, Article 9 of the Convention does not subject the jurisdiction of the court to the existence of pre-existing obligations, the requirements pointed out by Mr. Staker are simply without basis. The court may do well to contrast the submission by Mr. Baker, whereby Myanmar doubtlessly did respond to the note verbal by Gambia if it had been more elaborate, or would have responded rather, with the attitude of Myanmar when the report was submitted, that is to say, the report of the fact-finding mission. This simple fact allows the court to reject the assertion whereby that the month went by between the note verbal and the application, and that this allowed Myanmar to take a position. The respondent state had a month, actually only 13 days, to reject a sentence in a report containing 190 pages on 16 September. Mr. Staker maybe could enlighten the court as to the proper amount of time that, in his view, a state accused of genocide would have to wait before responding to such an accusation that has already several times been rejected. Mr. Staker has also questioned the reason whereby the note verbal was sent a week after Gambia procured the services of legal counsel and not before. And he reaches the conclusion that the note verbal was a mere legal formality. If by legal formality Mr. Staker is referring to the action confirming the existence of a dispute, then he has correctly identified the nature of the note verbal of 11 October, unless he considers that Myanmar's silence is tantamount to consenting of responsibility. He is simply confirming the existence of a dispute between the parties under the convention and before being presented to the court. Well, before he contested the plausibility of rights under litigation, which Gambia requests protection for, Myanmar expected this more than a month before. Mr. President, whereas Mr. Shabazz contested the plausibility of the claims, which is distinct from a subject from the one I am addressing, my colleague will be addressing that. He addressed the plausibility of claims. Mr. Staker, however, did not contest the plausibility of the rights which Gambia is requesting the protection for. He nevertheless considered that instead of maybe there being wrongdoing in these actions, Gambia may not have standing in this procedure. Mr. Staker did not contest that Gambia had the right to invoke Myanmar's responsibility as a state other than a wronged party under Article 48 and the Articles on International Responsibilities of States. However, he did consider that the invoking of such responsibility could not be done only under international relations, but not before a judge. He also said that the Belgium-Senegal case should be distinguished from this case because in that case, Belgium would have been a state that was subject of wrongdoing, but he separated this from Actio Populares. On this last point, Professor Sands will be responding to Mr. Staker, and I will thus limit myself to several observations on the alleged lack of standing. In referring to the judgment Belgium vs. Senegal, Mr. Baker did not explain the reason whereby the court first did not consider it necessary to identify whether Belgium had been affected, and secondly, where the court affirmed in general terms that vis-à-vis erga omnes partes obligations, the requirement of a specific interest would have as a consequence that no state would, in most cases, be able to present a claim against the state that had actually committed a wrongful act. As to the distinction between claiming responsibility in the context of international relations or before the court, this distinction appears to be particularly obscure and unjustified. Invoking responsibility before a judge in diplomatic relations is always intended to assert a breach of law. The distinction suggested by Mr. Staker does not appear in the work of the International Law Commission, and it is also contradicted by the Institute for International Law, when a jurisdictional link appears between the parties. Mr. Staker has also stated that the application for provisional measures is contrary to Article 41 of the statute and that it aims at preserving each party's rights. He did not make any explanations to this effect and did not contest that this language aims all rights under litigation before a judge. Finally, Mr. Staker says that through its reservation on Article 8 of the Convention, Burma was not, or the court rather, could not be seized and its jurisdiction could not be invoked. Because of the fact that Myanmar did not accept Article 8 of the Convention, no party then could bring a claim before the court, whereas according to the respondent, this article does give the court jurisdiction because of the consent to Article 9. Myanmar empties Article 9 of its meaning and provides no explanation as to what its meaning could then be at this preliminary stage, where its jurisdiction must be ascertained prima facie. So at this stage, the court should not consider this argument because it is a considerable departure from the good faith with any interpretation that should be made of this treaty. Mr. President, I would now like to request that you listen to Professor Philip Sands.